Yes,
Thank you, Chair. Oh, Chair, before we get lost in the questioning of Mr. Matlala, I just need to clarify something. The Chair ruled that the document that Mr. Matlala refers to, being as was described regarding, I think, Mr. Hangwani Maumela and Mr. Suleiman Karim, or one of them, which is part of the documents currently being collated by his legal representatives, which we have established is the SIU document and is available. The Chair ruled that it be made available to evidence leaders. I understood that there might be some challenges. I was hoping to have a quick chat with Ms. Missy before I address you to find out if there are challenges in regard to providing the evidence leaders with that document.
Chairperson, I did indicate I do have the document. It's in my file. Had you requested it before I'd run out, Ms. Matlala, I would have given it to you. But now that we're here, is it okay for us to give it to you once we've stopped, or do you need it right now?
I would prefer, before we rise today, that we have copies in preparation for tomorrow.
Okay.
Okay, thank you.
Thank you.
Then continuing, Mr. Matlala, we're still looking at the instances you met with General Sibiya. Do you know what investigations, if any, he did in regard to Mr. Boshoga's kidnapping? And my second question is whether he reported back to you about that.
No, he never reported back to me.
Never reported back?
Yes.
Did you have any dealings with General Sibiya after that engagement regarding Mr. Boshoga's kidnapping? If so, can you just quickly articulate the nature of the dealings?
Dealings meaning?
Any engagements with him, further discussions?
I think the engagements that I spoke about is the one that I said I cannot go into the details of that engagement.
Now, you cannot, okay. You cannot go into the detail as regards those engagements, and please say it again, because, what is your reason again? Which right are you asserting this time?
It's both because I've been questioned about him, and there's a statement that is made, the 204 statement, and also is because there's an investigation that is currently ongoing.
Okay. Then let's take it one at a time. The Section 204 statement is made by who?
By myself.
In which matter? Or regarding which investigation?
The Medicare matter.
Medicare matter.
Yes.
And I take it that a Section 204 statement is one that would effectively render you a state witness.
No, I'm not a state witness.
Okay, so what Section 204 statement are you talking about? Unless I've got my CPA all mixed up.
I do not know how, sorry?
Yes, I think Advocate Missy might help.
Chairperson, if I may interject at this point. Chairperson, you'd have noted earlier on we made reference to the fact that some of the claims to privileges that he wants to lay are in relation to the questions that were asked to him during the interview for this, and may be found in the Section 204 affidavit, which is a privileged document, and which is why we were of the view that the attorney on record would be another individual who is also an officer of the court who can confirm that he really is a suspect with regards to these interactions with said individuals, and therefore would be in a position to claim privilege. And so, which is the reason why Mr. Matlala keeps making the submission that I cannot speak to this here because I'm being investigated. I've addressed it in Section 204, and you would note that when you are being investigated as a suspect, as far as I understand, it's not specified to you that your charge is A, B, C, D, E, F, G. And therefore, it makes it even harder for him to pinpoint exactly why said information was required for me to give to the individuals during my Section 204. And therefore, I need to claim privilege over this particular point. Chairperson.
Oh, Ms. Silo will respond, but may I say this so long? My understanding of how Section 204 works is that somebody who may be charged of an offense or who has even already been charged of an offense may then be engaged by the prosecution to be used as a state witness. And then in terms of Section 204, that person may then be discharged in the sense that they will no longer be charged with that offense. But if they answer all questions truthfully and satisfactorily, and they're even called a Section 204 witness. So just before or what you called an interjection, Ms. Sillo wanted to understand if by his repeated references to his Section 204 statement, he is suggesting that he was or was to be a Section 204 witness. Yes, Ms. Sillo.
Indeed, Chair, that is what I'm trying to understand, because if it is in respect of Medicare 24, what we know right now is Mr. Matlala is an accused person. If he has signed a 204 affidavit, which as the Chair points out, he could be discharged from the charges that he's currently facing, and I need to test whether or not he's an accused or he has become a state witness in the Medicare matter, which, as I understand it, is the matter in which he deposed to a Section 204 affidavit.
Or if none of those, how then does a Section 204 statement feature?
Chairperson, my apologies. So the plea agreement fell through at that point, so it didn't become a Section 204, to my understanding. And so with that being said, that information then made him understand that with regards to point A, B, and C, D, I'm a suspect and I'm being investigated. And that's how we have come to the conclusion that he may be in a position to claim his right to privilege.
How do we, without sight of the 204, how do we as commissioners determine whether the reliance on Section 204 is properly raised? And that properly as in is, it's validly raised and it should be upheld.
Chairperson, in that instance, we tried to aid the situation or the dilemma that we also had come to, as per your question. And the only solution that we could come to is that the attorney, being an officer of the court, would be in a position to confirm that indeed, to the extent of ABCD, having read this affidavit, we can confirm. And I believe from that point, then it would put the commission in a better position to say, well, Mr. Matlala and through his legal team are actually correct when it comes to ABCD. But as it stands right now, it would be impossible for him to engage you with regards to those points. And again, as we had apologized with regards to not being able to deliver the replying affidavit timeously for the commission to have sight of it, because that's the main reason why we needed the instructing attorney to both have a look at the docket and the Section 204 and give the commission an insight into it.
If I may, I think there is a third option that perhaps Advocate Miss is not alive to, which is providing this commission with that Section 204 affidavit, even if it's on a confidential basis, for the commissioners and the evidence leaders to consider the contents thereof, to appreciate the rights that Mr. Matlala seeks to assert at every turn as a result of that Section 204 affidavit having been deposed to.
If I may just add to that, because I was going to say something along those lines, that if his attorney, and underline this which you said, is an officer of the court, and therefore we must take his word for it, why does that not apply to the evidence leaders who are also officers of the court and officers of the commission and the commissioners as well, as a quasi-judicial body made up of lawyers? Why does that not apply to them? And that's aside from the question of, surely you couldn't be saying that the word of the attorney must be taken to be the word of Mr. Matlala. And if the attorney says, that's what that affidavit says, we must blind to the document, and without it coming from Mr. Matlala's mouth, we must accept that what the attorney says, we have to make a decision on that basis. On what authority, on something so important and with far-reaching consequences, on what authority would you say we must proceed in that way? Because it's not just a matter of preference. You obviously prefer that. So put preference aside. It doesn't work on preference. It works on what is the authority for denying the commission the access to that Section 204 affidavit, especially where Mr. Matlala has repeatedly invoked it and offered. He's referred to it. It doesn't come out of a vacuum. We are having this conversation because the witness in the box keeps saying, it's in that affidavit. Why are we not entitled to look at it? And the answer to the why must be, on this authority, you are not allowed to look at that Section 204 affidavit.
Chairperson, if I might be given a moment to just confirm with my learned friends. Chairperson, if I may. Commissioner, in terms of Section 10510, when you're no longer a state witness,
Of the Criminal Procedure Act.
Yes, of the Criminal Procedure Act, you are then given a right of privilege over any information that you would have deposed to in the initial affidavit. And the moment you expose that affidavit, any and all issues that are addressed in that affidavit are now in the fray. And you waive your right to to not be, you waive your rights that's given to you in terms of section 105.10. Consequence to that, what we consider is that if there's even any other issue that he has addressed in that affidavit that he's given privilege over, even if you hadn't considered it, if we expose it to the commissioners and not through his attorney who has legal privilege, it then implies that you would have seen all the information that he's given protection over, which you wouldn't ordinarily be entitled to, which is protected not to disclose to anybody else, as we have now established that he's not a state witness, Chairperson.
Thank you, Commissioner. Perhaps we might benefit from taking a step back, and I do so by posing a question to Mr. Matlala. Mr. Matlala, you concluded what we call a Section 105 capital A plea and sentence agreement with IDEC, didn't you, in this Medicare matter?
Yes, that's correct.
And that agreement was presented to the court as it ought to be and was considered by the court, and the sentence was rejected by the court, and the court counter-offered with a higher sentence.
That's correct.
Which, in terms of the law, you have a right to consider, accept, or reject, and you elected to reject it on the 13th of July 2026 at your appearance in court.
Yes, that's correct.
And you accept that once you rejected it, the entire Section 105A plea and sentence agreement fell by the wayside. It became null and void.
Yes, that's true.
Now, the affidavit that we are discussing now, you deposed to in the process of negotiating that Section 105 capital A plea and sentence agreement. Am I right?
Yes, that's correct.
Now, both of them have since become null and void. Do you accept that?
Yes, I accept that.
Okay, this perhaps now to address myself to Advocate Misi. The subsection 10 of 105 capital A simply says that the trial starts quote unquote de novo, and the contents of those documents are not applicable as against the accused person in that particular trial. That's what the subsection provides. Now, Advocate Misi seems to extend that to suggest that both documents cannot be considered, even if it's not to determine the guilt or otherwise of the witness before us, but because they've become null and void for purposes of that criminal trial, therefore some privilege extends to them. I'm still unclear, Commissioners, what privilege exactly Advocate Misi is extending. Thank you.
If I may, Chairperson, I have here before me the actual provision. And at subsection 10, from letter number B, sub B. No, my apologies, sub A. Unless the accused consents to the recordings of all or certain admissions made by him or her in the agreement or during any proceedings relating thereto, any admission or record shall stand as proof of the admission if it does not fall de novo. So our understanding and interpretation is that the fact that he does not consent to waiving his right with regards to the information that he had given willingly in lieu of the fact that he would stand as a state witness, it then implies that he's covered not to disclose any such information that he had given willingly in lieu of the fact that he would be a state witness. The problem then becomes in the instance where this document is regarded as a privileged document. And by my understanding, and it is our argument, the submissions, right, that if we then say outside of his attorney and legal representatives who have privilege over this information, we hand it over to the commission, it then implies that not only are you going to be able to look at those particular statements that you're asking questions about, any and all information that is disclosed in there that you possibly have not even considered asking questions about. It puts us in a position where you have sight of it and you very well might say, well, but we think and we consider this not to be something that's privileged. And so I do not understand how is it possible that the commission would be able to close its eyes to any other point that's made there and only look at those particular averments that he makes that relates to the questions that you are asking. Because and our understanding is that the moment he says, you very well might look at that affidavit, he loses his privilege not to have that information that is given during those proceedings exposed.
Chair, if I may, and perhaps it's time to turn to section 105A. The rights that are protected in that section, particularly sub 10, which Advocate Vusi refers to, are intended to protect the accused against any prejudice as a result of the agreement concluded or the plea and sentence agreement in that particular trial. That's all. Advocate Vusi suggests that the privilege extends to the world at large, whereas the privilege in terms of the section itself protects the accused person in that particular trial, where he deposed to both the plea and sentence agreement and the section 204 statement affidavit. So, commissioners, I suggest there is no legal basis to refuse to provide both the sentence and plea agreement, which has since become null and void because Mr. Matlala rejected the proposed sentence on the 13th of July. And it is literally pro non scriptum. It cannot be used against him in that court. Similarly, the section 204 affidavit that he deposed to. Both documents can never be used against him in the trial that he's currently facing. Section 105, capital A guarantees him that. So if they are going to argue for non-disclosure, I submit that they have to advance a different legal basis for the non-disclosure, not reliance on section 105, capital A. This is not a court, a criminal court sitting in the Medicare contract criminal case. Thank you, commissioners.
Ms. Missy, well, first to make the obvious point, Mr. Matlala is not in a criminal court before us. He's not an accused before us. That's the one point that Mr. Lo is making, and it's my point too. But two, it seems obvious to me that Mr. Matlala can't have his cake and eat it. He can't invoke the section 204 affidavit when he's required to answer questions. He can't say, it's in the section 204 affidavit, and so I don't want to deal with it. And then at the same time, say you can't look at the section 204. Then if that were to hold, and I've said to you on what authority would that ever hold, if that were to hold, it would mean that, in fact, he just needs to assert it. He just needs to say that if I answer that question, or if I speak to that, whatever you're asking me, if I give you an answer, I'm self-incriminating. And if your proposition or submission is correct, it would mean that's the end of that inquiry. It would mean that. And I want to suggest to you that the correct position has to be that what he asserts when he invokes that privilege against self-incrimination, it requires that we must assess and evaluate whether that defense or that protection is being properly invoked. And the only way we can determine that is by looking at what it is that he's refusing to answer. I'm still to hear you say that we are wrong in that position, that in fact his say-so is sufficient. And if you're correct in that proposition, then we could never, ever, ever make any inroad with any witness, because all witnesses can come and sit here and say, well, you know what, there's a recording, and in that recording I say things that are being investigated. That's the end of the matter. Similarly, for section 204, all he needs to say is there is a 204 affidavit. If I speak to it in any way, then I'm incriminating myself, and that would be the end of the inquiry. We would never have a witness that answers questions. You may, if you have an answer, you may respond to me and to Ms. Silo.
Chairperson, it's not an answer, but my question then would be, are we to say that the rest of the provision that refers to during or any proceeding relating thereto, that in these proceedings in the commission, we are excluding the commission to include any proceedings relating thereto.
What
Because
is the relating thereto? What is the thereto that is referred to?
the agreement, to be precise.
These are not proceedings about the agreement. We're not having a trial that relates to anything that that affidavit may be covering. We are not having a hearing about that agreement if the thereto is the agreement. We are not doing that. We are engaging, and I want you to remember how we get to this point of discussing the Section 204, is because Mr. Matlala repeatedly makes reference to the Section 204. He says, I'm not answering that. It is in the 204 and all of that is being investigated, is under investigation. That's how we get there. And for me, the fundamental question is a witness entitled to say that which you're asking me is in a document, but you can't see that document, and that's a complete answer? It cannot be.
Commissioner, we're not saying that it's just in any document. We're saying that it's in a document that is privileged. And in terms of which that agreement, the moment you don't become a state witness, it falls away and nobody has to have sight of it, because it then goes to the fact that he willingly brought himself and has made admissions, all types of admissions, to which, as the commission, because you are investigating some of these occurrences, these events, and perhaps even the evidence that he makes reference to, it then implies that any witness that comes forward and says to the state, I am willing to be a state witness, let's negotiate. If that negotiation falls through, any commission at that point will not respect the fact that your admissions and the privileged document that you had entered into an agreement about is no longer privileged simply because you are called before a commission.
You see, we did not have, I hope you are listening to me. I hope you are listening to me. We did not have to get to this point, and I'm addressing you as well, Mr. Matlala, on this. We did not have to get to this point about whether or not this Section 204 statement or affidavit or the contents of it should be divulged. Mr. Matlala could and should actually have responded to the question directly. If Mr. Matlala said, your question relates to A, B, C, D point, which is about one of the crimes of which I have been charged, therefore I risk incriminating myself, that we would understand. There is no need for him to refer to the Section 204 statement as some umbrella cover for his protection. As I said earlier, there is authority from the Constitutional Court that says you must clearly identify the crime to which you are referring in asserting your privilege. And then that should take you to whether, in the face of that, the question put to you is a question that you should or you should not answer based on whether the privilege under those circumstances can be asserted. You don't have to refer to Section 204 or the statement that you made under Section 204 and to then use that as some overarching protection. Once it's in the statement, therefore, I cannot answer questions relating to it. It should not. I see your junior next to you is shaking her head. Maybe she's going to give you some brilliant point on why I'm talking nonsense. So we do not have to go there. We are not asking for the contents of the Section 204 statement. All that we want is, because Mr. Matlala is asserting the privilege, Mr. Matlala should say, this is the crime, and this is how your question impeaches on my privilege. That has nothing to do, and it should not have anything to do with reference to the Section 204 statement. It does not have to. And I repeat what I said right at the beginning, which is that without this umbrella cover all that Mr. Matlala uses, we should not have been in this position whatsoever. So much that I will perhaps, I'll let you respond, depending on your response after the advice from your junior. I will then ask Ms. Silo to repeat her question. And I hope Mr. Matlala has heard me when I say we do not have to just broadly and in general terms refer to a Section 204 statement and then say every and anything that relates to the questions you are asking me is contained in that Section 204. That's not the test. The test is there a crime? What is that crime? How does the question being put to you relate to that crime? And are you therefore entitled to assert the privilege? The test is not, this has somehow been touched on in my Section 204 state. That's not the test. That's simply not the test. Yes.
Chairperson, if I might just get a moment to just confer, because I can hear as well that my junior does have a few points that she perhaps wants to relate to me that I
Yes.
missed. Thank you.
Should we take an adjournment and you'll then indicate when we should come back? No, please feel comfortable. Don't rush yourself because you want to make sure that you will convey what's being said to you. But of course, we had indicated that we would be taking the adjournment at 5. Let's adjourn rather than us just sitting and watching. You'll indicate when you are ready.
Thank you, Chair. Yes.
Yes, Ms. Missy.
Thank you, Chairperson. We've deliberated about it, and I believe we had Edom with the last submission that you've made that relates to him having to specify what it is, what the charge is in particular. And therefore, we should allow Ms. Stellot to proceed and ask him the question and allow him to address it as per.
Yes, and I want you to, even if overnight now, but I'm sure your junior can assist even as we are sitting here. I want to have a look at paragraph 109 of, I think it was the first of the 2 judgments you referred to, Ms. Hassim. Yeah, let me.
Yes, Chair, it's the Secretary of the Judicial Commission and Zuma.
Yes.
And it's a judgment of Justice Jafta, which was, it's just because there are a few judgments in that case. It's the one that was decided on 28 January 2021. And the operative paragraph for our proceedings is paragraph 109 on page.
The neutral citation is square bracket 2021 close square bracket ZACC2. That's the neutral citation. Please look at paragraph 109 and you'll get the point I was making, and I hope your junior will now understand and not shake her head. Thank you very much.
Thank you, Chairperson.
Thank you, Chair. While on that point, perhaps it is necessary that we play a clip. This is an interview of Mr. Khanyago, the spokesperson of the NPA. And in the course of that interview, he commented about the legal status of the two documents that we are currently debating. With your leave, Chair. Mr. Matlala, if you could listen carefully to Mr. Khanyago's comments there.
The agreement is null and void, and we have to accept what the court has indicated. Obviously, it was not within our control as we had agreed, and when there was a change of sentence, and they had a right, obviously, in terms of the law, to either agree or not agree, which they did not do.
This essentially means, Mr. Khanyago, that you have to go back to the drawing board. Anything that was reached in that plea agreement, including what we understood from this court, was an affidavit which contained the names of very senior police officers who are alleged to have also been involved in this rogue tender. You cannot use that anymore. You go back to the drawing board. He then also has to join the other accused now who have been appearing in this matter. Clarification there.
Thank you very much. Yeah, definitely, because now the plea has been deemed to be null and void. Nothing that was in that plea can be used. Therefore, we have got to continue with our own investigations from IDEC side. And then, obviously, the matter will come back here on the 11th of September. And what will then happen is we'll then ask for the court to then rejoin him as accused number one in the other case, so that he can now be tried. Because by not accepting the plea, he's basically saying, I will run to go full force with the trial. Therefore, that's what is going to happen.
Thank you, Chair. Mr. Matlala, I hope you heard that. That is Mr. Khanyago, the spokesperson of the NPA, expressing the legal position as a consequence of your rejecting the sentence proposed by the court in the plea and sentence agreement. And the point he makes, which is what we've been trying to persuade you of, is both that plea and sentence agreement as well as the affidavit you deposed to in the process of negotiation of that agreement, which you refer to as the Section 204, affidavit have become null and void. So they will not be used in that trial. They cannot prejudice you in that trial. And as the chair, I think, pointed out, or Commissioner Baloyi, we are not part, this commission is not part of that trial. On that basis, Chair, I would seek to refer Advocate Missy in particular to Regulation 10, sub 6, which provides that for the purposes of conducting an investigation, the chairperson may direct any person to submit an affidavit or affirm declaration or to appear before the commission to give evidence or to produce any document in his or her possession or under his or her control which has a bearing on the matter being investigated, and such person may be examined by the chairperson or an evidence leader. That's Regulation 10, sub 6. I'll take it further and reference the rules, which at Rule 10 call for documents. At 10.3, the rule provides that should a person claim that a document referred to in the summons, which is the document required, is subject to legal professional privilege, they must, 1, identify the document in respect of which privilege is claimed, and 2, explain the basis for the claim of privilege in relation to each document. The remainder of that rule then deals with the questions of confidentiality and, of course, confirm the chairperson's discretion to determine that certain portions of such document or the document in its entirety is subject to a claim of confidentiality, which claim will be upheld by the chairperson. That's at the chairperson's discretion. Based, therefore, Chair, on Regulation 10.6, we would request that the commissioner's rule, the chair rule, that Mr. Matlala and by extension, of course, his legal team, make available to the evidence leaders and the commission, purely because Mr. Matlala, at every turn and in response to every question, invokes the Section 204 statement or affidavit to make available both those documents for consideration by this commission to determine the extent to which the contents thereof are relevant to the matters before the commission. Thank you, Chair.
Ms. Silo, I'm loath to make such a ruling without full written argument on the point. I'm not sitting here. I'm not altogether sure how Section 105A 10A should be interpreted for purposes of whether this commission can, regardless of the nullity, have access to and use the affidavit that was produced in the context of the plea bargain proceedings. Sitting here now, I'm loath to right away make that kind of of ruling. I would have to be addressed fully and with written submissions on the point. I was making a slightly different point when I engaged Ms. Missy right at the end before the adjournment. I was saying we got to the point that raised the question of whether this commission should have access to that 204 statement. We got to that because Mr. Matlala chose blanketly to rely on that statement to assert the privilege. And the point I was making was the proper approach for Mr. Matlala is in accordance with paragraph 109 of the Constitutional Court judgment to refer to a specific crime, the paragraph says so, and say because of that specific crime, this is how that question impinges on my privilege, and therefore I assert the privilege. For that purpose, he ought not to rely on the fact that he has made a 204 statement, because that doesn't specify the crime on the basis of which he is asserting the privilege. So that's why I said we ought not and we should not have reached the stage which we reached. We reached it because of the blanket manner in which Mr. Matlala kept referring to the 204 statement. We should not get there. I would suggest that between now and the time that we adjourn, you put your questions again. And Mr. Matlala, I repeat, and this was the purpose of the adjournment, I repeat that I will not accept blanket references to your 204 statement, because the 204 statement is not in and of itself a specified or specific crime, a specific crime for purposes of the judgment that I have referred to, and which is authority on how and under what circumstances you can assert the privilege. So do not again blanketly refer us to your 204 statement. Tell us the crime and then claim your privilege. So for now, let's just proceed with your questions on the basis that I will hear nothing of this blanket reliance on the Section 204 statement. And if you insist that we should have sight of that statement or affidavit, I will insist on being furnished with written submissions by both sides on that issue, Mr. Silo.
I accept that, Chair. If I may, with your leave extended, much as you say, Mr. Matlala, in refusing to answer a specific question posed to him, must specify the offense, which is what section, paragraph 109 of the Zuma judgment tells us. Equally so, the point I sought to make and the purpose for which we played that clip is that very document is null and void in the very criminal trial that he is currently facing. So he can't invoke it for purposes of a fear that it will prejudice him in those proceedings. So he can raise that as well.
Yeah. I hear you.
Thank you, Chair.
I think that's a valid point. Yeah,
Thank you.
I hear you. Thank you.
So then, Mr. Matlala.
I hope because when we took the break, Ms. Missy, that was the point on which I was engaging you. That is, I will have none of this thing, of this blanket reliance on the Section 204 statement. That's when you and your junior engaged each other, and when I said, let's rather take an adjournment rather than watch you engaging with each other. So I hope you did engage Mr. Matlala on the point, which is the point I raised with you specifically, and that Mr. Matlala now understands that he cannot in a blanket fashion just say, because this was in my statement. But in any event, Ms. Silo makes a valid point, which is that the fact that it's in that statement can't be used against him in the criminal proceedings anyway. I'm just expressing a hope that this was discussed fully. I hope I'm not inviting a debate.
No, Chairperson, you're not inviting a debate. I can confirm that we did impress on him and explain to him why you're taking issue with it with regards to the blanket statement. And so I do hope that moving forward, he'll be able to answer you as per that issue.
Thank you. And Mr. Matlala, the point I'm making applies across the board, actually. It's not just about the Section 204 statement. It applies to any and every issue that may arise upon, or rather, based on the questions that you are going to face from Ms. Sidlo. So you cannot, in very broad and generalized terms, say that's going to incriminate you. We should know what the crime is, and then based on that and looking at the question, see whether indeed you're asserting the privilege is warranted under those circumstances.
Thank you, Chair.
Yes, Ms. Silva.
I take it, Mr. Matlala. Did you want to say something, Mr. Matlala? You looked at the chair like...
Yes. If you want to respond, you may, Mr. Matlala.
No, I actually acknowledge what you were saying. There's nothing more.
Okay. Then how we got here, Mr. Matlala, was we were engaged on your third, fourth, whatever, incident where you met with General Sibiya and you said that he had invited you to discuss the kidnapping of Mr. Boshoga. You then suggested that you cannot go in any further detail as to that engagement, and for that purpose you relied on Section 204 statement. So now it says you can't, not in the manner that you choose to, because in any event, that statement itself has become null and void. So then I repose my question. Can you briefly state to the commissioners the nature of the engagement you had with Advocate Sibiya, General Sibiya, about the kidnapping of Mr. Boshoga? My apologies, General Sibiya.
I think on that issue, I already said that he asked me what do I know about it, or you want me to explain what did I say after he asked me what did I know about this kidnapping. Do you want me to explain what did I say to him?
Yes.
Okay. Yes, he started by asking me that why are they accusing me actually of that crime, and I took him back and I explained to him that as soon as Jerry's was kidnapped, I suspected two things. The first one was I went to Jerry's house together with Jerry's brother, and then Jerry's brother said to me, I must ask Jerry's wife to give me Jerry's cell phone, because should she find out that there is Jerry's side chick's number in that phone, she will go crazy. And then she said I must lie to her and say this phone is going for investigation. And I did that. That's the first point. So the second one is I told Jerry's wife and Jerry's brother that why don't we tell the police exactly what was Jerry doing, so that at least when they looking for him, they will know which direction to look for. And then I think those two things might have triggered what Jerry's wife did to end up saying, I kept Jerry at my house, which is not true anyway. So, but those are the things that I discussed with General Sibiya.
And are you able to say what was the outcome of that engagement? Because it's not clear whether he was talking to you or with you in his capacity as an investigator, having taken over the investigation, or purely as a senior police officer where others are investigating that kidnapping.
What he said to me is, he said to me that if he can crack that case, it will help him a lot. So I will assume that he was doing that as a police officer, obviously, because if he wanted to be the one maybe to crack that case, then he wanted to know what do I know about it, since Jerry was my friend.
And I think earlier I asked whether after that engagement you had any further interaction with him about this matter.
The kidnapping matter?
Yes.
No, he never, it was only that time.
Okay. Now, you recall that we were dealing with these issues because paragraph 2.2.3 and 2.2.4 had inquired of you the nature, extent, and frequency of communications and physical meetings with General Sibiya. We had said this perhaps is about your third encounter with him. When next did you meet with him and for what purpose?
The other encounter I said is the one that I do not want to talk about it because I'm being charged with corruption. I'm not talking about 204. I'm being charged with corruption, and then they also investigating him on that matter. So,
please say the last bit again, and also?
The investigators, they are also investigating him. Firstly, I'm describing the crime. So yes. I said I'm being charged with corruption.
Is this in the Pretoria case?
The Medicare, yes.
The Medicare case?
Yes.
Oh, this is corruption in the Medicare contract?
Yes.
Is it part of the ongoing criminal case, or would that be an extra charge?
Ongoing criminal case.
So you then, this corruption that you fear you may face a charge for arises from your physical meetings and gatherings and communication with General Sibiya?
That is correct.
And would both of you be charged with corruption, or just you?
I'm already charged, so I'm saying I do not want to say things that would end up making my trial difficult for me. Well, basically what I'm saying is it will infringe my fair trial rights.
Okay. So that will infringe your rights in the ongoing corruption charge in what we call the Medicare?
Yes.
Because corruption is one of the offenses you are charged with.
Is this the IDEC investigation?
Yes, that's correct.
And this would relate to your interaction with General Sibiya. You may disclose something, you say, that would compromise your defense against the corruption charge if you were to speak about this fourth interaction with General Sibiya.
That's correct.
Okay. And thereafter, any other?
There's two occasions, but both is the same corruption charge, yes. I'm not mentioning when I went to see him in his office for the Boshoga issue and also for the public works hospital lease.
So, if I understand you correctly, after your engagement regarding the kidnapping of Mr. Boshoga, you met with General Sibiya 3 more times.
Commissioner, I'm just saying on top, I cannot guarantee that it's 2 or 3. I'm just saying from top of my head, I'm not sure about that.
Oh, and where's my 3? You had said, I said, when was the next time you met? And then you brought up the corruption case in Medicare. And I say, beyond that interaction, any other, you say 2 other occasions. That's how I land on my 3.
No, I said except the 2 other occasions when we met in his office. 3 occasions, actually.
So now you had this interaction that could potentially undermine your defense in the ongoing corruption case. I want us to get past that interaction. I want the next time you met with him.
There is no next time.
Was that the last interaction you had with him?
Yes, the last interaction is I think is what is it? That engagement party. I don't think there was after that. I don't recall.
So the next time you met with him thereafter, to your recollection, was perhaps the engagement party you referenced earlier. You have to verbalize your answer.
Yes, I said that.
Don't nod, Mr. Matlala.
I'm sorry.
Thank you.
The recording doesn't see a nod. And since the engagement party and the interaction at the engagement party, have you had any meetings, physical or otherwise, communications with General Sibiya?
No, I've never.
When was this engagement party, to your recollection?
Sometime in 2024.
So you said, okay, you can use the season, winter, summer, I'm trying to.
I think it was towards the end of winter, if I'm not wrong.
So I can say mid-year 2024.
July, maybe July, somewhere there.
Did the other witnesses not say it was 14 September?
No, I'm not sure, Commissioner. I'm not saying that. I'm just...
There's confirmation that, yes, the other witnesses so said.
He might be right. I'm not saying that is the truth.
So then I'll accept that. The last engagement you had with, or interaction you had with him was at the engagement party in 2024, whatever the actual date was.
Not the last... The timelines, I'm a bit confused with them,
yes.
But it's one of the interactions, yes.
Okay, then let's get past the engagement party. When did you next engage and interact? After, now we have the engagement party in our minds. I trust fund was heard by all, so after that, when did you next engage?
What I can remember is our own...
Sorry to do this.
Yes.
There's confusion about the 3rd and 4th occasion. If the engagement party was in September,
yes,
and the raid was on the 6th of December, then it must mean the engagement party is the 3rd occasion and the raid is the 4th occasion. Because December comes after September.
Indeed. Do you understand?
No, I understand, yes.
Yes. Remember we discussed the kidnapping of Mr. Boshoga?
Yes, yeah.
And you said it was after the raid.
Yes.
So the commissioners point out to us that the order of things is not right. The engagement must have come before your engagement with him regarding Mr. Boshoga. Because that was only after the 6th of December.
Of course, yes, I agree.
So we should swap the dates around.
Yes.
You said yes?
Yes,
oh, you're still thinking. I don't know.
I'm thinking. I'm trying to remember. I'm trying to remember. I think, if I'm not wrong, I also met him in 2025. So I'm trying to remember while you're speaking. I'm sorry. So I was trying to get the exact date.
Then perhaps if we say, while we correct that you then met him next in 2025, perhaps if we discuss the circumstances of that meeting and what was discussed, that would help us sort out the order of things, hopefully. So what did you, in 2025 when you met, what was it about and where and how did it come about?
Commissioner, I'm saying I think I met him in 2025. I'm not certain, but judging by the timelines, because after the raid, I remember I didn't have, there was no way after the raid, first I'll say maybe 15 days, there was no way that I could have seen him because I was busy with police and then I was busy with my meeting with, so it must be maybe January, I think.
Oh, okay, I think I get you now.
I'm trying to have a proper recollection, so.
And is that in relation to the discussion around the kidnapping of Mr. Boshoga? That's the one you're putting it around January 2025, am I understanding you correctly?
Yes.
Okay. So then after the Mr. Boshoga discussion with him, when would you would have met again?
I don't think I've met him again after.
Since?
Yes.
Have you ever communicated with him directly or via Sergeant Ngosi?
Communication, yeah, I think there was a communication via Sergeant Ngosi, yes.
Are you able to just highlight what the communications was about and who had initiated such communication? And if they are different, then you can enumerate each and talk about who had initiated and what each communication was about.
The communication was through, all the time, was through Sergeant Ngosi.
But at whose instance?
If I remember well, the communication was regarding after the raid, why did I tell the police that I know him? So, I think it should be in December. After the raid, maybe before January, I think there was a communication.
Okay.
I'm just confused. I'm not. Okay. I'm sorry. I am not.
Are you now referring? Remember, there were 2 raids in December. There was a raid at your house.
Yes.
Where the police were looking for Mr. Boshoga. Then there was a raid at CAT VIP services where there was the issue with the key and the fact that it's not in the right safe and firearms were taken. Which raid are you referring to?
After the first raid, I think 10 days after the first raid, that's when, 10 days after the first raid, that's when I made that High Court agent application. And in that High Court application, that's when I mentioned that I know General Sibiya. So that's when I get a message from Sergeant Ngosi that why did I mention that I know him? Because it was in the media, I think. So that's why I'm saying I think in December there was some communication.
So after the 20th of December?
Yes, somewhere there, yes.
Thank you. So do you recall having a discussion with General Sibiya about an application that was necessary to launch for the return of the guns and I think jewelry you said had been seized during the raid of your house or office, one of them?
Yes, but that is part of the case that I'm attending in the Johannesburg High Court.
Medicare?
No, not Medicare, the other one. In Johannesburg High Court.
The one concerning the conspiracy to commit murder, attempted murder, yes, and lawful possession of a firearm and ammunition, money laundering.
Yes.
What relevance does General Sibiya have?
There is a relevance because I have my defense. I need to establish how did I end up being arrested. So because in my phone records, they are relying that I'm part of me and General Sibiya and Minister Mkhunu, we part of people who plan to dismantle this PKTT unit. So that is something that I'm going to argue in trial, that how did I end up getting arrested?
What is the crime in dismantling the PKTT?
The crime?
Well, you said, perhaps I misheard you, my apologies. You said there is an accusation that yourself, General Sibiya, and Minister Mtunu are what about the PKTT?
Commissioner, when they did my cell phone downloads, there was communication which I do not want to, but it's part of evidence in my criminal court in the Johannesburg matter. But there is those engagements, and where also General Sibiya has been involved there.
You said something about the PKTT. Can you say that again?
The dismantle, of the team.
Oh, yeah, okay.
Yes.
So that's why I say, what is the crime in disbanding the PKTT? What's your understanding arising from that case?
Not the crime, not the crime, Commissioner. I'm saying part of my defense. I'm going to establish in court how did I end up getting arrested. The only way for me to explain this to you now, I have to go deep, and which I do not want to do that, and now disclose my defense strategy.
No.
I do not want to do that.
I'm not inviting you to. I was talking about an application you initiated or instituted in December.
Yes.
For the return of your guns and jewelry, which had been seized during one of the raids.
Yes.
And I asked the question whether you had not engaged with General Sibiya around that application for the return of your property. So your response then speaks to the criminal case of murder and attempted murder and the disbandment of PKTT. And I'm not sure I understand.
Because your question, what you're asking me now, is also part of evidence. What you just asked me now is part of evidence, which is in my cell phone downloads.
Isn't that perhaps, Mr. Matlala, the best way to proceed is the direct question that is asked is, you had such an application before court where you went to court to seek a return of your firearms. That's what Ms. Silo has asked at this point. So it seems to me that your answer would be yes, I did, or no, I did not. And then we pass that, and let's hear what is the next question before you get to a point where you say, but that case has to do with the matter that I'm presently facing in the defense. So maybe take it step by step. At this point, all she asks is, you had such an application where you went to court, you wanted a return of your guns and jewelry. And answering that question at this point does not require you to get into the detail of that application, and I don't know if she intends to ask you that further question, but at least as a starting point, your answer doesn't require you to speak about what was in that application.
Commissioner, I already conceded that yes, I made that High Court application, but her next question was, did I ever discuss that with General Sibiya? That was her question.
And your answer could be yes or no. And if she says, what did you discuss? It seems to me that at that point, you may well attempt to raise your defense, your privilege.
Commissioner, I don't think this is fair, because now I'm disclosing part of my defense strategy now. I don't think that is a fair move. I don't think so.
You're not, at least as I understand, you're not saying, I don't want to answer that question because it will incriminate me. You're saying, I don't want to answer the question because I don't want to disclose my defense strategy.
That's correct.
So it's the second one.
Yes, that's correct.
And Mr. Lowe will decide whether that's good enough for purposes of further discussion.
Well, I would think that, and perhaps it's a tad unfair to Mr. Matlala, because the answer really lies in section 3 sub 4 of the Act, which means he must invoke some legal privilege. And in regulation, I think 610, it tells you that the only basis to refuse to answer a question is if you establish a privilege contemplated in section 3.4, which is a privilege as recognized in law, and fear to disclose your defense as not one such privilege. So if that is the only basis, then you do not bring yourself within the ambit of the protection, because that does not constitute privilege, and you will be compelled to answer. You are raising a wrong basis to refuse to answer. It's not an acceptable basis, as determined by the law, not by us around here.
Maybe, Commissioner, is because you are speaking to, I'm just a mere layman. I do not understand law, and then I do not know which case law I should invoke in these things. I think maybe my legal counsel will help me with that. I do not know how to invoke which section for that.
I think that's fair. That's fair. So maybe to address myself to the commissioners and ask the commissioners to inquire from Advocate Misi whether she would like to engage with that point on your behalf.
Thank you.
Thank you.
Ms. Missy,
Should I answer?
what are your
May I answer
submissions,
rather?
your submissions in response?
Yes, Chairperson.
Does the privilege extend to not, or rather, a witness saying, I will not answer because I do not want to divulge or reveal my defense strategy?
Chairperson, at some point, you raised the question as to what exactly is this charge that you are facing that speaks to that particular piece of evidence and defense that you would not like to disclose before the commission. One, because we were only briefed with regards to the proceedings before the commission, we're not fully aware as to what are the charges that he faces in that matter that speak particularly to that piece of evidence. For us to then say to Mr. Matlala, we do understand you, and from this perspective here, you would be able to claim your right to the privilege in terms of section 3.4. And so, Chairperson, the only thing that I could do at this moment is if the commission could allow us to stand now so that we can consult with regards to this issue, bearing in mind that we're also in a back footing with regards to the charges that relate to that case before the Johannesburg High Court, I believe.
Just repeat the underlying facts that give rise to this issue, so that when instructions are taken, they are taken in the context of the point from which you moved to,
Yes.
for us to get to where we are now.
The chair will recall that Mr. Matlala and I were recounting the incidents he met with General Sibiya and they discussed, and the idea was to understand the content of such discussions on each incident. And I had posed a question to him whether he had met with General Sibiya regarding an application he instituted for the return of his firearms and jewelry, which he stated at the time had been seized during one of the seizure, one of the raid incidents, either at the home or subsequently at his office. And he confirms, yes, he did institute those proceedings. So the question was whether or not he met with General Sibiya and discussed that with him, to which then he claimed he invokes a privilege, not in the Medicare matter that we've been dealing with, but the other matter in Pretoria, I think, about conspiracy to commit murder, attempted murder, unlawful possession of a firearm and ammunition, as well as money laundering. So it is in the context of understanding the charges that he's facing there, I'm trying to appreciate what his engagements with General Sibiya regarding, I would term it, the lawful return of his property, what bearing it would have on that case. And that's where I think we fail to find one, or I fail to understand. Let me lay it on my doorstep.
Thank you. Yeah, maybe for a fuller background, during the raids, some of Mr. Matlala's company's properties, and indeed even his personal items were allegedly with regard to the personal, and I think it's common cause with regard to the property belonging to the company were taken by the police during the raid. And the alleged relates to, I think, Mr. Matlala, in a court application in which he was seeking a mandamus, in terms of which he said his, amongst others, his Rolex watch, or was it a Cartier? Oh yeah, a Cartier and Rolex watches, and maybe some other personal item had been taken by the police. So in terms of the mandamus, he wanted the court to direct that those items be returned. But if my memory is correct, I think in the end he either withdrew or did not pursue those applications any further. So that's the full context. And so Ms. Sillo is engaging Mr. Matlala on that. Sitting here, I have no idea how that has anything to do with Mr. Matlala's defense strategy, but in any event, there's the point that Ms. Sillo makes, which is what's Mr. Matlala's defense strategy got to do with the privilege he is claiming, which is the privilege against self-incrimination. So that's the full context. Would you still say you want to take instructions, or would you accept that there is no basis for asserting the privilege in this context? Or perhaps it's not even the privilege, it's some other animal, an animal that I will not answer the question because it discloses my defense strategy. But in any event, I just do not see how an application for the return of Mr. Matlala's personal items, I do not see how that relates to any possible defense to whatever charge he is facing in this regard. But in any event, there's the antecedent question. Can he refuse to answer the question on that basis in any event?
Chairperson, while Mr. Matlala was giving his submissions, there was a point at which it seems to me that he makes reference to the issue of a charge and or within the case that he's referring to. And I'm wondering to myself, without having full knowledge, is there a misunderstanding on his part that we would need to consult with him about so that we're able to correct him and give legal advice as to whether he's approaching it incorrectly? This is the manner in which you would have to make the application or claim the right to privilege. Because I do specifically recall him making reference to a charge that relates to the matter. And that's why I'm saying I don't know what the charges are. I don't know how it relates to this particular piece of evidence that, or rather the issue with regards to the application not proceeding, how those two interlink, because now suddenly, or rather later on, he makes reference to it being part of his defense strategy. And as he noted, because he's a lay person, he perhaps might not be viewing this correctly, but he actually knows what he's trying to say.
Is that a point he can raise as a matter of law anyway? That is, I will not answer that question because it discloses, or rather my response will disclose my defense strategy. Is that a legal basis for refusing to answer a question?
Chairperson, now that we have taken the instruction and we've decided to proceed based on where we are, having not heard the application or proceeded with the application at the point, I believe during our consultations and as part of the application, it called into question as to whether as a suspect or as an accused, does he have a right in terms of Section 35, and it would go towards the issue of a fair trial, which there's a confusion with regards to that. I'm just off the top of my head on his part. And that's why I deem it important before we proceed for him to answer it, can we get an opportunity to understand exactly what is this point that he's raising that has to do with the charge and the evidence, as well as the defense that he wants to raise in the trial, Chairperson. I do believe, as he noted, that he's a lay person and lacks a proper understanding how. It's also to avoid an instance where, again, it's just regarded as a blanket approach of, because I am going to use this as a defense in my trial, therefore I don't want to address it. I do believe it's important that we get the opportunity to get an understanding exactly from why is he referring to this, why did he mention the issue of a charge, how does this all interlink, and then we can give him proper advice that in terms of claiming privilege, you have to make reference to the specific charge, etc., before we...
I have bent over backwards and allowed you an adjournment each time you ask for one, but we will never finish Mr. Matlala's testimony if at every turn we have to do this. We have to adjourn for you to take instructions, and I thought this is just a legal question, and sitting here I just do not see the connection whatsoever with regard to an application, a civil application for the return of Mr. Matlala's goods, and an application which he did not pursue. He either withdrew it or did not pursue it to finality, so it died a natural death. I just do not see, sitting here, unless we get clarity, I just do not see how that has anything to do with his defense. But as I said, the antecedent question is, can that even be raised as a basis for not answering the question?
My question to that would be no, given where we are in terms of the proceedings. However, I still stand by the fact that he very well, just on that particular point that he tried to explain or go further on with regards to the charges, he very well would be able to explain to us at least so that we can give him proper legal advice as to whether he can claim a right based on that or not. Because Chairperson, like he said, he's a lay person. He's probably trying to approach it from this angle, but in reality, this is exactly what he's meant to be claiming based on ABCD. I don't know what the facts are, as much as I also don't know what the charge is that he was trying to make reference to. I think I'm grappling with the fact that he did try and address the issue that has to do with charges, and it relates to the defense that he wants to raise. I also don't understand to what extent it would affect his ability to raise the privilege to not self-incriminate. However, I do agree with you that he can't raise the issue of fair trial, i.e. with regards to disclosing his defense, Chairperson. And that's the reason why I've asked for a stand down, so that we can at least give him that legal advice so that he understands where we are right now.
Yeah, you see, the difficulty with that approach is that it would be a matter of relative ease for every and any witness to say, I will not answer that question because it discloses my defense strategy. In circumstances where, when you look at the facts, it does not immediately spring out, the circumstances do not spring out and tell you in and of themselves that this has something to do with a possible defense. Civil case, civil application, withdrawn, and apparently, at least from the evidence that we have had, on the basis that no Cartier or Rolex watches had actually been taken from Mr. Matlala, how that should then lead to the disclosure of his defense in the criminal case, for the life of me, that escapes me altogether. So the short point I'm making is it would be a matter of relative ease for anybody to say, I will not talk about that. That discloses my defense. And if there is no cogent explanation, we cannot accept that. We simply cannot accept that.
Sorry, Chairperson. I think maybe I can assist if you allow me.
Yes, please.
Because I have to agree with you. You are right with one thing when you say you don't understand how this civil matter has to do with my criminal matter. Even myself, I didn't see the necessity of why the state will bring that up. But as you're saying, anybody can come up here and say this will infringe my fair trial rights. So I think what is best that I can do to prove that this thing is part of my trial and then is part of the case that the prosecutor has been relying on. Maybe if I can bring maybe a copy that is signed by the investigating officer to show that indeed this is part of my case. Tomorrow morning, I have that document on me. I can bring it tomorrow morning.
I see that it's 2 minutes to 6. Perhaps we should adjourn at this stage, and then that should afford you sufficient time, Ms. Missy. And yeah.
Chairperson, before we do adjourn, I would like to understand the position with regards to the suggestion that Mr. Matlala has made, which is to provide...
Can you please...
My apologies. Yes. I would like to understand the position with regards to the suggestion that has been made by Mr. Matlala, which is that perhaps he ought to provide us with a copy, because as I stated, I haven't seen it as well. I don't know what these charges are. And so it's so difficult for me to answer you and address you with regards to that. And maybe he does have a good point to make there. So what is the position to that?
No, that's acceptable. That's acceptable. Yes, you may bring that document you want to bring, Mr. Matlala.
Thank you, Chairperson.
Yes.
And Chair, before we adjourn, perhaps then to facilitate our engagement, it might assist if we were provided with both the charge sheets and you call it the Pretoria matter, the attempted murder case, and the Medicare. I'm not asking for your dockets, I'm asking just for the charge sheet, because that would give us a sense of what the offenses Mr. Matlala is charged with.
I think I have my charge sheets. The charge sheets, I don't know, I will ask. It's fine, we'll make a plan.
Thank you.
Chairperson, because if I may, I believe Mr. Maluleke is the attorney on record in those matters.
Of course, yes. Yeah.
And he's still on record here. Surely that would be relatively easy for us to provide same.
Thank you.
Thank you, Chair.
Let's adjourn and resume at 9:30 tomorrow.